Hello, Attorney Ashley Lambert here with the Ashley Lambert Law Office. What can you do when a parent constantly violates the court-ordered parenting agreement involving parenting time, custody, what have you? What can you do? Well, there's a few things we can do. One is we can ask the court to hold a co-parent in contempt. Ask for a contempt action. Now, before you do this, you should know that a contempt action could result in serious consequences, such as jail time here in the state of Arkansas. Now, it could result in jail time. Not always, but that's on the extreme end of things. So out of that, what can we ask the court for? Well, before I divulge into that, I want to say, if you notice, I said court-ordered parenting plan. This means that if you have a parenting agreement, even if it's in writing, the court nor will the police officers take action if you were to complain to them that mom or dad has failed to meet at the meeting place. So there must be a order that has been filed by the court before any action can be taken. Obviously, or of course, there are exceptions. One being if the parent who is the petitioner reasonably believes that the child is in immediate danger, then the officers or officials can get involved in implementing or accessing the children. So we ask for a contempt action, which, as I said before, it could lead to serious consequences. But you can always ask the court if the respondent, the co-parent, has been found in contempt, or even if not, ask the court for a few other things. You can ask the court for makeup time. And makeup time is basically exactly what it sounds like. Ask the court to grant you the time that you didn't receive, but you should have according to the agreement. Okay, so let's say you and your and the co-parent agree that the two of you will alternate weeks in a month. Okay, so on your week, it just so happened to be spring break week, and mom decides that, oh, I'm just going to keep them next week because I'm going to take them to Disneyland. Okay, spring break is about a week long. And so therefore your week has been cut into. So where you would have had 2 weeks that month, because mom decided to keep the children for that whole week, you only had 1 week that month. So what you can do is ask the court for an extra week the following month, or beginning that week. It depends on what day the hearing falls on. You can ask the court for that week back. Therefore, you would get 3 weeks and mom will get 1 week the following month, and then you're back on your original schedule. So that's one thing you can do. You can also ask the court to order that co-parent, let's say dad, pays your attorney's fees. You could show that but for dad failing to adhere to the parenting agreement in which the court has ordered, you wouldn't have had to hire an attorney to get this hearing. Therefore, he should have to reimburse your attorney's fees. If you can show that that is the reason and he's the reason for it, and you have evidence to support that he actually violated the court order, it's up to the court's discretion, but it's a good chance that you'll have your attorney's fees paid or ordered, that the other parent pays your attorney's fees. Okay. Now, if the co-parent, whether it be mom or dad, is a habitual rule breaker, habitually not following the court's order, you can go all out and ask that the court modifies the parenting plan. Okay? And depending on how serious these allegations are, you can ask that you have more time throughout the month, maybe 3 weeks for you and 1 week for him or her, or just every other weekend for him or her, because, you know, women violate these orders just as much as men do. So there are many things that we can ask the court for if there is a proven violation of the parenting plan. So you must prove, if you are the petitioner asking the court, okay, asking the court for a contempt action or asking the court for some type of relief due to a parent's refusal to comply, you have the burden of proving, demonstrating that the co-parent has failed to comply with the court's order. So how do you do this? How do you prove that the other parent is in violation of the court's order? One way is if the meetup, the drop-off pickup place is at, let's say, McDonald's. Well, the parent who was there, go in and order fries. And on that receipt, you will have the date and time stamp. Okay? Also, if you are meeting up at anywhere, really, police station, and just go to a nearby convenience store, again, buy something. You can also take a picture of the meetup spot, and don't just take a picture and say, okay, that's it, I have my evidence, because we can argue that the picture could have been taken any place. So take the picture, you can argue that the picture could have been taken at any set date. Take the picture and text it to the other parent and say, hey, I'm here, right? So those are different pieces of evidence or different ways you can get evidence as to that the other parent has been in violation of the court's order. Now, when do you do this? When do you file a motion to request a hearing for whatever reason due to violating the court's order? Well, you don't want to do it the first time it happens, any alleged violation happens. You want to allow the non-compliance with the order to happen more than once. You want to, show a history of deliberate violations. All right. So once you have your evidence compiled, then you seek an attorney to write a motion requesting a hearing, and so forth. Now, one thing you want to do before you file your motion is make sure that you have what we call clean hands, okay? This means that you yourself are in compliance with the court order. Now, if you file a motion and you show up in court alleging that dad is not complying with the court's order, and dad surprises you with his own evidence that you hardly ever complies yourself, and you just so happen to catch him on the times that he was not complying, the court isn't going to be too pleased with that. And if dad requested you pay his attorney's fees for pulling him into court, the court just might order that and affirm the order, the parenting plan as it is, if you were requesting that it be modified. So keep that in mind, that you want to make sure that you are innocent yourself before you go in and request that the court takes any action in your favor against the co-parent. All right? Thank you again. This is Attorney Ashley Lambert with the Ashley Lambert Law Office. Feel free to leave questions or comments below. If you would like to contact us at ashley@alambertlaw.com. You can also visit us on the web. Our website is below also. Thank you.